I'm not wrong.
You're right. Yes. Yeah. 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 Once again, to recapitulate, we are now dealing with the chapter in evidence and inquiries and trials. That is chapter number 23, commencing from section 272 till 299. So far, we have covered that the evidence must be taken in the presence of the accused, with a view to enable the accused to know exactly what is happening. Then record in summon cases and inquiries how the memorandum is prepared by the learned magistrate. Then record in section 275, record in warrant cases how the learned magistrate prepares and what is the effect of this memorandum under section 80 of the Evidence Act. Court shall presume it to be correct. Now, today we are dealing with section 276. Have we completed? Yeah, to take it now. Record in trial before a court of session. What is the, because the trial before a court of session commences under chapter 18 of the CrPC, commencing from section 225 onwards. 225 से लेकर 237 is the, you must remember this, is a trial before a court of session. Now, open 276. Yeah. In all trials before a court of sessions, the evidence of each witness shall, as his examination proceeds, be taken down in writing, either by the presiding judge himself or by dictation in the open court under the direction of the superintendents by officer of the court appointed by him in this. I think this we have covered. This section has been covered, isn't it? The dictation is taken down. I won't again repeat it here. The learned session judge records the evidence or directs this to be taken by the judicial clerk, isn't it? Then the language of the court 277 is either in the state of Maharashtra Marathi language or in English. So far as practical, it should be signed by the magistrate and the presiding judge. That is what the mandate of section 277, and should be signed by the persons, the witnesses in the matter.
Sir,
Yeah.
I think I have mistaken. We have completed till section 288 as Bharat is informing me right now.
Yes. Yeah, please, sir, because we are relegated back 288. You're right.
Yes, you were correct that we are doing
Yes.
commission, sir.
Return of commission. So those people who are unable to come before the court of law, the court will appoint a commission for recording the evidence. This provisions of section 285, 86, 287 or analogous to section 75 and order 26 of the Code of Civil Procedure. Okay. Now come back to return of commission section 288. I think we have completed this. We have completed this, isn't it? After the commission is used under 284 has been duly completed, it should be returned. This I think is completed. Then subclause 2, a deposition taken satisfied the condition prescribed by section 33 of the Evidence Act. So I mentioned to you that yes, section 33 of the Evidence Act comes into play where there are parallel proceedings. Where there are parallel proceedings, the effect of deposition before the court under section 30. In fact, in Salman Khan's matter, 304A IPC, the learned session judge got carried away by wrongly invoking section 33 of the Evidence Act. Why I tell you that here? The High Court rightly set aside it by admitting the appeal and granting. Why? Because the learned session judge while giving a final verdict in the court of session against Salman Khan in a drunken driving case, he relied upon the statements given by his bodyguard, namely the Havaldar who used to protect him. You know that, no? There's a Havaldar who was assigned to Mr. Khan, who was traveling along with him. And he was in fact the eyewitness when the accident took place at Bandra, when 4, 5, 6 people were mauled down under his SUV. Then immediately the Havaldar went and lodged a complaint to the Bandra police station. FIR was registered by him. In the FIR registered, he said that Mr. Khan was drunk. We had gone to Juhu. I went along with him. He came from a pub. He was in intoxicated frame of mind. He himself was driving and he committed this offense. He drove down on the people who were sleeping on the pavement. So the learned magistrate of the Bandra 9th MM court recorded the statement of the Havaldar under section 200 CrPC. You know that's a verification statement. In the verification statement, the Havaldar police put a complete blame on the Khan that how he was intoxicated and he was responsible for the accident. So then later on the matter, you all know that you travel to the court of session. The court of session, while adjudicating, giving a final judgment, relied upon the statement given by the Havaldar under in the Bandra Metropolitan Magistrate Court under section 200 CrPC. You know, under section 200 CPC and the CrPC, that statement, the learned magistrate record the evidence of the complainant and the witnesses for the purpose of taking cognizance of a complaint under section 190A, B or C of the CrPC and not for any other purpose. Those witnesses whose evidence is recorded, they are not cross-examined. Please note that. The accused does not have the opportunity to cross-examine them. The learned magistrate does not even issue notice upon the accused person to cross-examine. This is only with a view to prima facie be satisfied whether the complaint file is correct or not. It is a pre-cognizant stage where the magistrate take cognizance. But section 33 of the Evidence Act clearly mandate, when you open section 33, section 33 evidence cannot be used unless the other party had opportunity to cross-examine the witness. Please open section 33 of the Evidence Act. Yeah. Relevancy of certain evidence of proving in subsequent proceeding the truth otherwise of the stated. Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it, relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same proceeding, the truth otherwise of the fact, stages when witness is dead, cannot be found, incapable of giving evidence, or is kept out of the way by adverse party, or if the presence cannot be obtained without amount of delay, expenses, so and so. So one of the condition precedent is that here the evidence must have been recorded in a former proceeding. Now in the case of Salman Khan, the former statement of the Havaldar recorded by the magistrate is sought to be used. Now the proviso, see that here, provided that the proceeding was between the same parties or their representatives, no problem, this will apply. Number two, that the adverse party put in the first proceeding had the right and opportunity to cross-examine. Underline this word. In order to invoke section 33 evidence in parallel proceeding, the witness ought to have been cross-examined. If the cross-examination does not take place, that the evidentiary value of that witness is zero. Please note that. If you're in the judicial proceeding, either in the civil court or in a criminal court, you examine a witness, your examination chief under section 137 CrPC takes place and no cross-examination, the evidentiary value is zero. Please note that the witness must be subjected to cross-examination, then only the evidence can be considered. Otherwise, the court will take that evidence with a pinch of salt. Iska matlab zero value. So the High Court rightly admitted the appeal and granted the stay of the judgment of the session judge, which was basically the learned session judge got carried away with the newspaper report. He is a film star who killed many people, and it is all trial by media, which is unwarranted. A session judge should not do that. Any judges, magistrate or a session judge or a high court or Supreme Court should not, because there are several judgments and strictures passed by the court, they should not be a media trial. So in Salman Khan, what was the conviction was passed in a media trial? Not permissible. See, the gentleman, the evidence was recorded of a Havaldar in a 200 proceeding CrPC, where it is for taking cognizance, where he had no opportunity to cross-examine. So the evidence has to be discarded at the final stage. That evidence can only be used for the purpose of taking cognizance, namely whether I should issue process or not, whether a prima facie case is made out or not, whether I should, that is the only, even for the purpose of issuing order under section 153 CrPC, verification is not necessary. There is a judgment of the Supreme Court of Justice Chandrachud and Justice M.R. Shah recently passed out, recently delivered, I gave you, that there is no necessity. There is no necessity. Same thing happened in one of the Bombay Magistrates court, Andheri court, passing an order under 156.3 without recording verification. And the Bombay High Court committed an error, quashing the proceeding on the ground that the learned magistrate has not applied his mind, did not give an opportunity of record evidence, he did not lead evidence. That is unwarranted. When you are issuing an order under 156.3, please note that there is no necessity of recording evidence. There is no question of going for verification. Similarly, for invoking section 33 Evidence Act, in a other proceeding, in a parallel proceeding, maybe a civil proceeding, maybe a proceeding from session court to Supreme Court, a high court, a judicial magistrate first class, wherever it is sought to be used, that statement under section 33 can only be used provided the witness whose evidence was recorded was subjected to cross-examining, or at least the other side was given opportunity to cross-examine. Other side may decline the opportunity, wo alag baat hai. Despite giving 3-4 times, he did not avail the opportunity. That is a different thing. But in a case under section 200 CrPC, by no stretch of imagination or by necessary implication, any witness would be cross-examined, because at this stage, this is an interlocutory stage, the learned magistrate is not issuing process nor calling upon the accused to cross-examine. So 33 cannot be invoked in such a matter. Please note that here. That is the meaning of here. When in the provisions of section, कहाँ पे use किया हमने ये? The word 200 and yes, yeah, 290 execution of a, I'm sorry, 288 return of commission, deposition taken if satisfy the condition prescribed by section 33. So one of the condition is that here the witness ought to have been cross-examined, otherwise you cannot take the evidence. The evidentiary value is 0. Of the evidence set may also be received in evidence at any subsequent stage of a case before another court. So this is what you must, as a young lawyer or a law student, should know, that here 33 can only be used provided is in a circumstances all the parameters and requirement of section 33 are met. Now come to please 289.
Sir, we have one doubt from one student.
हाँ पूछिए.
He is asking whether this is applicable to section 164.
Section 164 is a confession recorded by the magistrate. It's a confession recorded by the magistrate, isn't it? That the accused is, of course, you have a right to cross-examine. If a person is admitting his guilt, who will cross-examine him? Who will cross-examine him? Unless he himself retract the statement. Upon retraction, the prosecution can cross-examine him. समझे ना आप? 164 statement are admissible under section 80 of the Evidence Act. That's a memorandum the court shall presume to be genuine, and they are receivable in evidence. But if the accused says that my statement under 164 are not voluntary, I have retracted them, the learned magistrate did not explain to me properly, I was in an intoxicated frame of mind, I was not in a position to know, I had I was whatever maybe I was you can see I was an insane person, or I was in a drunken condition. I am not in a fit position to know. I was suffering from a mental disease. Yes, are various factors. In that event, the prosecution will seek an opportunity to cross-examine him. When cross-examination is done, yes, then if a person dies later on, or if it is to be corroborated, it can be used under 33. Otherwise, it cannot be done. Okay. 164 is a confession. Yeah. Anybody has any more doubt?
If the confession is of the complainant, then what about that? It will be applicable for cross-examination?
See, complainant confession, what is a complainant cannot confess? What is the complainant himself is an agreed person. Complainant is not committing any crime. It is the accused who is committing the crime. Confession is with regard to commission of the offense. Why should the complainant confess?
Sir, but in matters such as POCSO and other high-profile matters, for example, in Ahuja matter, the actor, in that the confession 164 statement of that victim was taken.
Yeah, victim guy is taken. The victim makes a statement that is in rape cases, because that is a safeguard to them. But they are treated in the nature of a confession, but she is required to be subjected to cross-examination.
Yes,
because that is a mandatory requirement now under section 164. The statement of a victim need to be videographed and to be taken in all rape cases, outraging the modesty cases, and all POSCO cases, isn't it? So there it is not a confession of the crime. It is a statement which is recorded in the nature of FIR. समझे ना आप?
Yes, sir, but
it's a statement in the nature of a FIR which is authenticated in the presence of a magistrate, because the police officer is not trusted. The police officer is an executive officer, whereas a judicial magistrate is a judicial officer. So the statements of a victim when recorded under 164, the magistrate will prepare a memorandum. That memorandum becomes admissible under section 80, but the accused will have a right to cross-examine. Please note that. The accused has full right to cross-examine the complainant in that regard. Full-fledged opportunity must be given to the accused to cross-examine the whatever the victim has stated is not a gospel truth. It is subject to rebuttable evidence or irrebuttable evidence. If the accused says that I want to cross-examine, he will lead evidence. I was not there at the scene of the offense. She is alleging of a rape in Mumbai. I was in Calcutta at that time. I can prove that here. So he is leading a rebuttable evidence, and she stands discredited under section 146 and 155 of the Evidence Act. Her former statement will be disproved, that the complaint is totally false. But if her statement is corroborated in material particulars, if the accused has not cross-examined her properly or given the opportunity not cross-examine at all, then that statement will go against the accused and he will be convicted solely on the basis of the confession under section 164 given by the victim in the matter. Okay, that can be used under section 33 of the Evidence Act. Okay.
Thank you, sir. Got it.
Is that clear now? Anybody has any doubt? Yeah. Next. Adjournment of proceeding. Adjournment देखिए. In every case in which the commission is issued under 284, the inquiry, trial, other proceedings may be adjourned for a specified time, reasonably sufficient for the execution and return of the commission. So normally when the court appoints a commission for recording evidence, say for example, a junior advocate is appointed for recording the affession of the inmates who cannot come to court, a senior man who is in bedridden, So that sufficient time should be given to the commissioner to collect the court papers and issue the process and read the papers and execute the commission. He will give a notice to both the parties, prosecution and the witnesses, that I have been appointed as a commissioner for recording the evidence of the witness on so and so place. I hereby fix the date of the commission to be executed on so and so date at so and so time. You may remain present. So he will request the honorable court, my lord may till then adjourn the proceeding for a period of 2 weeks, 3 weeks, 1 week, depending on how long the witness deposes. So when adjournments are normally granted, normally a criminal trial is required to go from day to day trial. When a commission is appointed, normally there will be a little break. Okay. Then execution of a foreign commission, the provisions of section 286, 286 and so much of section 287, 288 as related to execution of commission and return shall apply in respect of a commission issued by any of the court, judges or magistrate, hereinafter mentioned as reply to commission under section 284. The judges of the magistrate referred to are any such court magistrate exercising powers within the area so and so as the central government may by notification in this issue. Then C, the court may, the magistrate exercising jurisdiction any such country, place outside India, the central government may by notification specify in this behalf and having territory authority under the law in force in the country, place, issue commission for the examination of the witness and relation to criminal matter. So 290, from 284 to 289 speaks of domestic commission, 290 speaks of foreign commission. The witnesses may be in America, London, Canada, isn't it? Then you require the sanction of the central government. The central government has notified. So India is a signatory to various conventions. We are members of the UN. So whichever countries we have treaties and we are allowed, the central government will say, yes, you are allowed to execute the commission in this A country, B country, C country. It will take some time. So we examine Hadley in bomb blast case from America, who is a citizen of the USA, and he deposed against the bomb blast victims, giving evidence against Pakistani witnesses and who blasted the country. So one of the cases, if you read, you come to know that here. So for the role of the central government come into play in that regard. Okay. Now deposition of medical bid. Now this is called a special. Now what we learned so far is a special rules of evidence, general rules of evidence, right from section 137 Evidence Act, section 135, 136 with regard to the manner how the evidence is asked, documents are preferred, and the judge is the learned judge or magistrate giving order with regard to admissibility and relevancy of a document, relevancy and admissibility of question, whether to admit or not to admit. That is all general rules of evidence governing under the provisions of Indian Evidence Act, as well as section 272 till the provisions of section 290 are general provision. Now section 291 se lekar and till the end, they are special rules of evidence relating to special witnesses, medical witnesses, identification parade witnesses, and chemical analysis witnesses, which we shall deal with. Now please come to section 299. The deposition of a civil surgeon or the other medical witnesses taken and attested by the magistrate in the presence of the accused or taken on the commission under the chapter may be given in evidence in any inquiry, trial, other proceeding under this code, although the deponent is not called as a witness. So here the medical witnesses, they come into play a very important role. You know that in murder cases, you require the medical witness. Number one, you require the autopsy report. The autopsy report, we have a to determine what is the cause of death. We have a famous leading case of the Supreme Court, R.M. Malkani versus State of Maharashtra, where tape recording evidence of the gentleman R.M. Malkani was serving in Mumbai as the coroner of Bombay. Have you heard of anybody coroner? a coroner's court is a tribunal which holds inquiry with regard to the death of the person, the deceased, how he died. He examines medical witnesses. Now, the famous case, when I am dealing with the tape record evidence, I will deal with the case of R.M. Malkani versus State of Maharashtra, the AIR 1973 Supreme Court. When you see that, in that case, the R.M. Malkani, the great gentleman, unfortunately, he was one of the son of a magistrate. Unfortunately, he demanded bribe from a doctor. If you want me to hush up the entire matter, that you are responsible for giving injection, as a result of a patient died. You want me to hush up the matter? You please give me some bribe, which was conveyed to him through one of the another doctor, Dr. Motwani. Motwani went and lodged a complaint with the CBI, Anti-Corruption Bureau. His voice was recorded in tape recorder. Whether a tape record evidence is admissible or not was a subject matter of evidence before the Supreme Court. In that case, the Supreme Court held that if the voice of the person who spoke is identifiable, and the tape record evidence is admissible under section 6, 7 and 8 of the Indian Evidence Act, will come to it. So, यहाँ पे medical witnesses में basically the autopsy report is one of the report which is comes into consideration. Medical officer gives it here, the cause of death, how he died. A post-mortem report, all of you know that, the post-mortem, मरने के बाद the operation होएगा, find out how he died. Everybody knows what is a post-mortem. Autopsy report. There is also inquest Panchanama report. You know that under section 174 of the CrPC, I told you last time, like in Sushant Singh murder case, the death was uncertain. We do not know whether he committed suicide or whether it was a murder. So the government of India, Maharashtra, held an inquest Panchanama, inquest report, inquest inquiry by the magistrate. Under section 174, you hold the inquest inquiry, by the investigation by the police officer. When the police officer is not performing his duty properly for A reason, B reason, the learned magistrate conducts an inquiry under section 175, 170. So those are all reports which are special reports who can be called and deposed before the court of law to find out what is the cause of death. They are medical witnesses. So a doctor will tell you, you and me are not expert. They are also expert witnesses. They will give you deposition. No, the patient died on account of what? The blood was oozing. How many hours? Whether the weapon is capable of causing death or injury which is sought to be complained of. ये सब चीजें. After the receiving injury, within what time he died? How did he die? Whether it is a natural death, unnatural death. So these reasons are given by medical officers. So they are brought before the court of law. They can be directly brought before the court for giving. Without the medical evidence, you will not be able to prove the autopsy report, the post-mortem report. They are necessary, important. They can be examined on commission. They can be brought directly in the court of law. Number one. Subsection 2 check कर लीजिए. The court may, if it thinks fit and shall, on the application of the prosecution or the accused, summon and examine any such deponent as to the subject matter of the deposition. Okay, if the prosecution has not examined a material witness, the accused can make an application that this honorable court be pleased to issue witness summoned upon the doctor. This particular medical report is not has not been explained properly. The police officer has not exhibited this report. I am calling upon him to produce it. This honorable court be the surgeon who conducted the surgery has not been examined. So I would like to ask him what was the treatment he has given the victim, isn't it? How did these all the mode of treatment? When did he die? The facts to be ascertained. So it is the liberty of the prosecution as well as the accused person are liberty to examine as many witnesses. There is no bar, both under the Code of Civil Procedure as well as a CrPC. Now, under the Code of Civil Procedure also, you can examine medical witnesses. Now, CPC contains an extremely important clause suppose when a commission is examined, medical evidence is given. Suppose an ex parte decree is passed against you, your client. Your client will take up the plea that here he was suffering from a particular disease. He was under the treatment of a doctor. The medical doctor's evidence is conclusive. He should not be normally called as a witness at the interlocutory stage. When you see order 26 का explanation open को बताता हूँ मैं. Please open order 26 of the Code of Civil Procedure. Yeah, order 26 rule 1 check कर ले यहाँ पे. See, any court may in any suit issue a commission for the examination on interrogatories or otherwise of any person resident within the limits of the jurisdiction who is exempted under the court from attending the court or who is from sickness or infirmity unable to attend. The language under section 13. Now see, the provided that a commission for examination interrogatories shall not be issued unless the court for reason recorded necessary. Now explanation check कर लीजिए. The court may, for the purpose of this rule, accept a certificate purported to be signed by a registered medical practitioner as evidence of sickness or infirmity of a person without calling medical practitioner as a witness. Please note that medical officers should not be trouble in the court of law unnecessarily. Suppose a decree is passed against one of the defendant in the civil suit for not filing written statement. Defendant will take up the plea that here I was bedridden, I was under the treatment of a XY daughter. As a result of a decree, you have been dispossessed. Without when you are dispossessed, you will take up the plea that yeah, I could not. You made an application under Order 9, Rule 13 CPC, exhibiting doctor's certificate of your illness. So normally the court will attach significance to the medical certificate at that interlocutory stage. Unless you have made a blatantly false statement, such a doctor doesn't exist, then under Order 19 CPC, you can make an application to cross-examine. Please note that under Order 19 check लो CPC के अंदर, when accused person, when a defendant or any other person has a right to cross-examine the deponent, that is a valuable right here that you should know in the CPC. Affidavits के अंदर at the interlocutory stage के अंदर Order 19 check कर लीजिए आप. Yeah. Order 19 में आ गए आपने? Yes. Procedure. Please see that special rules of amendment matter affidavit. Where do you get it? Order 19. Yes. Order 19 मिला आपको? See power. See affidavits. Power to order point to be proved by affidavit. Then see Order 2 check करें. Order 19 Rule 2. Power to order attendance of deponent for cross-examination. If you think that the doctor has given false affidavit, you may take up the plea as a plaintiff. My lord, I have seen defendant roaming around very well happy, and defendant takes up the plea. He was suffering from sleep disc problem. He is bedridden for the last 2 months. You have evidence to show photograph. He was attending the wedding of his friend in the neighborhood. So you say that take up the plea, the doctor has given false affidavit. So under Order 19 Rule 2, you can make application for cross-examination. You can put it that this man has made a false statement with a view to obtain surreptitiously adverse orders against the plaintiff. So normally, when the court is of the opinion that the defendant was really sick, prima facie sick, and other side is not disputing the proposition of sickness, and medical evidence is taken as accepted, and doctors should not be unnecessarily called. That is also even Supreme Court in Jacob Martin's case has held that criminal prosecution under section 304 1A B should not lie against the prosecution as a matter of course, only in cases of gross negligence. In one of the lectures, I will cover it, how to draft a complaint against doctors under 304A for gross negligence, whether you can go for the damages under the law of tort, invoking the plea of, invoking the doctrine of interlocutor res integra. But whereas the Supreme Court says in Jacob Martin's case, doctors ordinarily are people who are saving the lives of the people. They should not be ordinarily called to the court, and the court should not lightly issue process against them. It is only in gross cases of negligence only summons can be issued. So but when it comes to these are interlocutory order. When it comes to final order trial in a murder case or a rape case, without medical evidence, you cannot prove it. A rape has taken place, you require to prove whether the serum test was done, whether it is the doctors, the various tests, MRI, ये सब जो भी कराते हैं यहाँ पे, CT scan or anything, all these medical examiners are normally called before the court. Sometimes they are called formal witnesses, sometimes they are called material witnesses, sometimes they are called very important witnesses, sometimes they are called special witnesses. Sometimes injury is not disputed, they are called formal witnesses. If the injury is very open and not disputed, the doctor only has to give opinion. This injury has resulted on account of this particular weapon. It is capable of causing serious injury in that matter. So, the provisions of yeah. Deposition 291 हो गया अभी. Come to 291A. Identification report of a magistrate. So the question which your student asked me about the victim statement can be clarified here. Identification report of a magistrate. There is the Identification Parade Act in Maharashtra, in India. All of you know that here. Now that Identification Parade Act, देख लीजिए आप कहाँ पे है, बोल लेता हूँ. This is of the which year? If you can open Kumar, Identification of Prisoners Act of 1920 खोल लीजिए. Identification of Prisoners Act of 1920. मिला आपको? These are very small section where
Yes,
ज़्यादा
sir,
नहीं
मिल
है
गया.
about उसमें that you remember it as a student of law, you should know that ये identification कहाँ पे आता है. Identification, suppose if 10 people have committed the offense, they kill, and which of them the witnesses are not sure, it is improper to convict any one of them unless proper identification is done. So identification is done normally in the presence of a magistrate, and the witnesses are told, you please identify कौन किसको देखा आपने, who is the, because in the police report में you must have given XYZ, he is a 5 foot and 6 foot, the Gora, Kala, Neela, you will give the name, because sometimes the police officer, overzealous police officer, with a way to frame anybody having enmity or taking a bribe and set up anybody. So इसीलिए with a view to eliminate the possibility of an innocent man being trapped, so identification is held under the Identification of Prisoners Act. So this is one done. That kind of evidence is led under section 9 of the Indian Evidence Act. Evidence of identification, when you open section 9 खोलो आप Evidence Act, आपको मिलेगा how where evidence of such evidence is held. Section 9 खोल लीजिए आप. See, fact necessary to explain, introduce relevant fact. Fact necessary to explain, introduce a new fact, relevant fact, which support or rebut inferences suggested by the fact in issue, relevant fact, or which establishes the identity of anything or person. Underline this word. Establishing the identity of any person or thing, this evidence is allowed. Because section 6 से लेकर section 52 tells you what is a relevant evidence. Section 5 tells you what is you are required to lead evidence only with regard to fact in issue and not any other fact. Section 6 to 52 tells you are allowed to lead evidence relevant fact. The judge may ask you, a magistrate, ये जो सवाल पूछ रहे हैं आप, how it is relevant, under what provision? If you are asking with regard to identification, you must say, my lord, this is relevant under section 9. If it is relevant with regard to motive, preparation, conduct, बोलेंगे, he had the animosity because the A killed B because he saw the accused person in a compromising position with his wife. समझे ना? That is why he committed his murder. So the motive was to take revenge. That was the motive. Or there was a decree, passed against him, ordering him to evict the premises. Instead of vacating the premises, he committed the murder. So that evidence will be led under section 8 of the Evidence Act. देखिए, motive, preparation, previous or subsequent conduct. A conduct kaisa, for example, if I announce in the government law college that the police is coming to look out for a student who has robbed the golden ring of a young student, a lady student. So suppose when I made announcement, one of the student gets up and runs away, disappears. That shows his conduct. He is one of the culprit. That conduct evidence can be led to show that here he is a culprit in the matter. समझे ना आप? Okay. Yeah. 278 हो गया. डॉक्टर का हो गया ना हमने? Yes. Deposition of medical evidence. Now identification आ जाइए. 291A. Any document purported to be a report of identification under the hands of an executive magistrate in respect of a person, property may be used as evidence in any inquiry, trial, other proceeding under this code, although such a magistrate is not called as a witness. Why? Because identification report of a magistrate is a memorandum under section 80. Please note that, of the Evidence Act. Open karo section 80. Presumption of a document produced by record of evidence. Whenever any document is produced before a court purported to be a record of memorandum of the evidence of any part of the evidence given by a witness in a judicial proceeding or before an authorized officer by law to take evidence or to be a statement of confession by a prisoner, accusation taken in accordance with law, purported to be signed by any judge, magistrate or any officer, the court shall presume the document is genuine. So here the confession statement recorded by a magistrate under 164 or a identification parade done by the executive magistrate holding the inquiry that 10 people have committed the offense. We brought about 25 people to identify. The identification was done in my presence. The magistrate prepares the memorandum. That becomes admissible under section 80. Okay, that is what here in the matter here. Yeah. Next is a proviso में आ जाइए. Provided that when such report contain a statement of any suspect or a witness to which provisions of section 21, 32, 33, 155, 157 as the case may be of Evidence Act apply, such statement shall not be used against the section except in accordance with the provisions of those sections. Section 21 of the Evidence Act, section 21 speaks of admissions. Admissions are applicable to both civil cases and criminal cases. Admission must be categorical in order to be admitted. It's not an evasive one. Evasive nahi rahega to nahi admit nahi hoega. Isn't it? So you will find admission provision section 21, 22, 20, 18 से शुरू होता है. Section 17 Evidence Act खोल लीजिए आप. Section 17 onwards से. Yeah. The provisions of section section 17 से लेकर 21, 22, 22A, 23, they come their admissions. That is not applicable. Is said that here. That is what a reference is made to section 21. 32 is a dying declaration. A dying declaration, and there are 7 examples when a dead person's statements are admitted. A will is made, isn't gone. The contents can be proved, isn't it? A person before death, he tells his wife, I am going to the house of my friend who invited me for dinner to settle our civil cases. Then next day he doesn't turn back. His dead body is found. So whatever he stated to his wife last night, and she will give evidence that my husband told me these are the circumstances relating to his death. But before his dead body was found, he told me he is going to the defendant's house to settle the matter and going for dinner. So dinner में मालूम हुआ कि उसको जहर दिया गया है. A medical report shows that the presence of a poison. Medical report. So the poison ought to be deemed to have been given by the opponent in the matter, because the evidence of the wife, who is the last seen witness, is admissible, who is giving the circumstances leading to the death in the matter. Okay, 32. Section 33 to abhi padhe humne. The evidence given in former proceedings can be invoked in subsequent proceeding, provided the provisions of section 33 and proviso cross-examination opportunity is given. Okay, 33 aa gaya. 155, 157. 157 and 157 deal with impeachment of the proceeding. You have a right to contradict a person. The former statements are incorrect. These are the rules with regard to Evidence Act, which strictly applicable in identification ke andar, subject to the provisions of section 21, 32, 33 and 155, 157. That means a cross-examiner has got a substantial leverage to expose the truth otherwise of the witness in the matter. Otherwise, the statements are acceptable by the court of law of the statement recorded by a executive magistrate under the provisions of section 290B identification, subject to the other provisions of Evidence Act. Okay, now the court may, if it think fit, shall on the application of the prosecution or accused, someone examine the magistrate as the. So despite the fact that the evidence of the magistrate is treated as shall presume under section 80, if the evidence is suspicious, sometimes even magistrates are human beings. Here the executive magistrate, who is not even a judicial magistrate, a special executive magistrate who doesn't have power to convict persons in the Indian Penal Code, who can record evidence, but his memorandum, the magistrate may say that let the magistrate be subjected to cross-examination. Because this is with a view to Supreme Court say that justice should not only be done, justice should seem to have been done. So the accused should not have an apprehension looming large in the horizon in his mind that he did not receive justice. So his advocate, the accused person, has every right to cross-examine him and demolish the contradiction, if any, in this regard. So with a view to keep the slate clean, a transparency in the matter, judicial proceeding, every accused person and every prosecution also is given opportunity to examine witnesses and cross-examine witnesses. Okay. Now 292 pages, evidence of officers of mint. This is also a special evidence. Any document purported to be the report under the hands of such officers of any mint or any note, printing press or any security. The printing press, including the officers of controller of stamp and stationery or any of the forensic department, division of forensic science laboratory, a government examiner, question document or a state examiner, questioning document as the case may be, as the central government may by notification specify in this behalf upon the matter, or thing under this code may use as evidence as inquiry under the proceeding under this code, although such officer is not called as a witness. The court may, if it think fit, summon. So, in cases where the jali note fabricated, counterfeit coins and notes are prepared, isn't it? Such evidence is a serious matter. The offence is a triable, cognizable by the court of session. In such officers, the mint officer, the forensic department officers can be examined to prove the truth of this. These are special evidence rule with regard to evidence of the mint here, which we should take into consideration. The central government plays a role in the matter here for examination of the experts in the matter. How expert evidence is given in the matter, how the Department of Forensic Science and even under the Evidence Act, these are known as expert evidence under Section 45. When you open Section 45 खोल लीजिए आप Evidence Act. Yeah, opinion of expert, Section 45. 45A, opinion of the examiner, see, examiner of electronic record. 46, opinion as to handwriting. 47, opinion as to electronic signature. 47A, opinion as to existence of a right custom. 48, opinion of usages. 49, and 50, opinion of relationship. 50, grounds. 51, opinion on relevant facts. Then this is very important. 45 to 51 relates to experts' opinion in that regard, which also section 292, 291, 292 CrPC must be read along with section 45, section 45 to 51 of the Indian Evidence Act. Please note that here. So what the central government, then the subclass 2 check the court may, if it think when someone the examine. Normally they are formal witnesses. The examiners, the printing press ke officers, note printing officer, Department of Forensic officers, they give the opinion. Mere affidavit is sufficient. But if the accused feels they should be cross-examined, in the bomb blast case, you know that here several affidavits were filed of the various officers to prove that here how the bomb was defused, how the electronic records were produced in the matter. That is Ajmal Kasabs versus the state, that is a case. You must know that it's a very beautiful judgment relating to all this forensic record and forensic evidence in that given. Now subclass 3 check लीजिए. Without prejudice to the provisions of 123, 124 of the Evidence Act, no such officer except with the permission of the general manager or any officer in charge of a mint or the note or printing press, so and so department, forensic laboratory, government examiner, so and so examiner, may be permitted to give evidence derived from any unpublished official record which report is based on, or disclose the nature of a particular of any test applied by him in the course of examination. So, and the secrecy demands sometimes public interest. You are not required to disclose the evidence before the court of law. Section 123, 124 of the Evidence Act, I read out last time to you that unpublished reports of the government evidence cannot be given unless the department consents to it, unless the government of India consent to it. So in one of the matters which went to the Supreme Court was Indira Gandhi versus Rajnard. The election record of Indira Gandhi was sought by Rajnard from the legislature of the UP as regard the amount spent on the election of Mrs. Indira Gandhi, because as a prime minister she cannot utilize any member of the parliament cannot utilize the public fund in that regard. So the Indira Gandhi and the government of UP took up the plea that these are unpublished report of the legislature, we cannot disclose. A court repelled the contention. The Supreme Court gave a balancing judgment. These are one of the example. Section 123, these are like in the nature of a privileged document. A communication between husband and wife cannot be disclosed in the court of law unless certain guideline. A communication between the client and the lawyer cannot be divulged unless a fraud is committed. These are the section 122, 123, 124, 125, 126 of the Evidence Act. When we take up the lecture next year, we'll come to know that. So elaboration is not required here. So the reports, then it is subject to the discretion of the court. They can be examined or they can be formal witnesses. 293 पे आ जाइए. report of certain government scientific experts, any document purported to be the report of the hand of the scientific expert to whom it is a section apply, or upon any other things submitted to him for the examination or analysis of the report in the course of proceeding under this record may be used as evidence at trial. DNA report, RNA report, whether the child is born to the defendant or plaintiff or not, whether the husband always alleges, I was out of India, my wife has given birth, he is an illegitimate child, and I will not give right, I will divorce her. So such proceedings have come before the court. Section 121 of the Evidence Act come into play. So DNA report ka examination can be examined by the expert, from the scientific expert, from the doctors, by the court of law. Though there is a uproar in the legislature and parliament here, the parliament must amend section 121 of the Evidence Act and allow CNA report, the report of RNA and the CNA might be made compulsory. The parliament is not agreeable because having regard to the condition of women in India, which is given special status by virtue of Article 15 of the Constitution of India. So we are protecting our women, rightly or wrongly, whatever reason may be, though the women are entitled to equality before the law, equal protection before the law, but they have special rights which are required to be respected. So then 293 also speaks of the various reports, which reports, you see, 294A, the chief controller of explosive, director of जहाँ पे आग लगी उसके अंदर, how the result of explosive bomb blast हो गया, how the bomb blast, in what capacity, what is it, which company it was made, what is the duration of time. So this controller of explosive will give his expert opinion. Then director of a fingerprints bureau, the fingerprints bureau will give it here. Whether the accused after commission of the offense has touched this particular instrument belong to him, weapon belong to him. A fingerprint expert will give an opinion. The police officer, while conducting investigation under the provisions of 157, 158 of the CrPC, he will take the report of the fingerprint expert. देखेंगे soil के ऊपर किसका खून था, that the blood will be examined by the serologist, by the prints will be, you have seen many of the Hindi movies, the accused person always wearing gloves and not touching the dead body or not touching the accused. So that is with a view to show that here the fingerprints are not. Then the director of Hafkin Institute of Bombay is an institute which performs such various scientific expertise in the matter here. The court will examine them. What are the various the tests which are conducted. Then director of a central forensic laboratory at Kalina and Hyderabad, Bangalore mein, a forensic laboratory will tell you exactly whether the cause of death, how the chemicals are used, whether the bomb blast took place, whether what is the cause of effect. Many things are discovered by the expert. A forensic laboratory in the matter, they give it here. So they come under the provisions of section 293 is very important, please. Then the law says 294, no formal proof of certain document. Where any document is filed before any court of law for the prosecution of the accused, particulars of any such document shall be included in a list of the prosecution or the accused, and as the case may be pleaded for the prosecution of the accused, and shall be called to admit genuineness of the document. Ye padhe humne. The list to be prepared, subclause 2, where the genuineness of a document is not disputed, such document may be read, evidence in inquiry, trial, or other proceeding under the court without proof of the signature in that regard, provided that the court may in its discretion require signature to be proved. Now even under the Evidence Act, section 57, 58, check karo, admitted fact need not be proved. Please just open section 57, 58 of the Evidence Act. 56 and 57. 56 खोलिए, certain facts need not be proved. See, fact judicially noticeable need not be proved. 56. 57, fact which may be taken judicial notice of. The court will take a judicial notice of certain things. All the laws of England. I will not be reading the entire section. आप देख लीजिए 57 के अंदर. 58 के अंदर facts admitted need not be proved. Bomb blast हुआ था. When you read the Ajmal Kasab's case, Several affidavits were filed by many experts in the matter. So they were not called as a witness, they were not required, the prosecution did not insist. If the prosecution insists or the session judge tells it is necessary to examine, cross-examine, there is a provision to examine. There is no bar as such. Even under the Code of Civil Procedure, Order 19 contains a provision for cross-examination. Under the Evidence Act, Section 137 contains a provision for cross-examination. So there is always a room for cross-examination, but formal witnesses, admitted facts, and where the evidence the court can take a judicial notice, they need not be proved. Section in the Evidence Act, please remember section 56, 57 and 58 of the Evidence Act. Padhi aap. The Evidence Act itself dispensing with the requirement of examining these witnesses in this regard. So this is very clear to you. Then 295 speaks of affidavit in proof of conduct of public servant. Normally, Evidence Act says that affidavits are no evidence. Please read section 1 of the Evidence Act. Evidence Act कहता है कि when you see section 1, section 1 of the Evidence Act, check karo aap. It is called Evidence Act. It extends the whole of India. It applies to judicial proceeding or before any court, including court martial, so and so, judicial proceeding, so and so, but not to affidavits, underline the word, presented to any court officer, not to proceeding before arbitrator, shall not come into force. So arbitrators are excluded from the purview of Evidence Act, affidavit are excluded. But under the CPC Order 18 Rule 4A tells you examination chief can be conducted by affidavit. There's a specific provision. When there's a specific provision, it is admissible. Now, under the CrPC, section 295 says that affidavit can be proof of evidence. So, when there is a specific provision, that specific provision will override the general provision of section 1 of the Evidence Act. See, normally an affidavit prepared by you from a notary public is not evidence. You brought affidavit from the judicial magistrate, Kila court mein jaake mare, your passport is lost, you brought affidavit, it is not evidence. It has to be corroborated. You must go in the box, must go deposit, and these are contents are correct. This is my signature. I stand by it. They are correct. The court will take on record. Normally they are not. But under the provisions of Order 18, Rule 4 CPC padhe aapne, examination chief can be by way of affidavit. So whatever you have mentioned in affidavit, court will not put you narrate the entire evidence. Court will only ask you, this is my signature, I have filed the affidavit, the contents are correct, the same may be taken on record in evidence. But the cross-examination cannot be filed by affidavit. Now, 295 dekh lijiye aap. When any application is made to any court in the course of any inquiry or trial or other proceeding under this court, any allegations are made therein respecting any public servant, applicant may be given evidence of the fact alleged by the applicant affidavit, and the conduct may fitting for order the evidence relating to evidence to be given. So the court got discretion to accept the affidavit or call for the evidence. Then evidence of a formal character on affidavit 296, evidence of a person whose evidence is of a formal character may be given by affidavit, and as such exception read in evidence inquiry trial. The court may, if it think fit, shall on the application of the prosecution accused someone examine the person as the case may be. So the court may say that here the commissioner was examined to record evidence. Commissioner bolega affidavit is copy hai. Why you need to examine the commissioner? Isn't it? There are lots of instances where the chemical examiner given report, I have examined and tested, it contains a poison. It poison number so and so. So admittedly the person died of dhatura, poison. The medical expert gives evidence that dhatura is found in the. So if he is not available, the witness is gone out of India, foreign country, he sent affidavit, can be accepted. Unless you want to cross-examine, challenge it here in the matter. वो अलग बात है. So 295 के अंदर. So we'll stop it here. One more last lecture will take it to conclude the evidence. I will give a overall picture of the entire evidence and complete the remaining sections of CrPC, Evidence Act, and also CPC. I will complete in the next lecture on Monday. Monday, I think we have Justice Oak's felicitation ceremony. Little 6 o'clock. Okay, 7 o'clock I can attend the lecture. No problem. I will be attending. You also can attend the Bombay Bar Association. We sent it here. Justice Oak has been elevated to the Supreme Court. He was our Bombay High Court judge before becoming the Chief Justice of the Karnataka High Court. One of the finest judges. I appeared before him. He deserves to be in the Supreme Court. So his felicitation is there on Monday. After felicitation, I think 7 o'clock is fine. I will point out certain provisions and complete the provision with relating to evidence. In CrPC, almost we are completed. Remaining 2-3 are there. Complete करेंगे. CPC भी लूँगा मैं आपका. CPC evidence is also very important. You should know the civil procedure complete trial. Or I will cover in one lecture itself and connecting it with the Evidence Act. Now, anybody wants to ask me any question, please do feel at liberty to ask me before we conclude. Now, we have already passed 1 hour. Anybody has?
Hello, sir. Good evening.
Good evening, beta. Boliye.
Sir, actually, I had a question under Section 45 of Evidence Act.
Yes.
Under there, in the comment section, I just didn't understand one thing. There was this comment known as corroboration of dying declaration by medical evidence. I didn't understand the whole thing.
Yeah, very good. Corroboration means supporting evidence of other witnesses. The word corroboration you will find in section, open your Evidence Act, section 150. Corroboration मिलेगा आपको section 159 में मिलेगा आपको, if I am not mistaken. 159 is a refreshing memory. 156. Question tending to corroborate the evidence of relevant fact admissible. So dying declaration is given. Normally suppose a person has a knockdown on the road, main road, and he or she brought before in the hospital में nurse के पास, doctor के पास statement करी, I was knocked down by the scooterist who is my neighbor with whom I have inimical terms. He wanted to kill me. Statement is normally a dying declaration. No? The person dies after 2 days. That statement is a dying declaration. Corroboration means that the medical officer coming and giving evidence, and corroboration maybe you will prove the record of the court where the litigation is pending to show that there was a previous enmity between you and the dead person, the family. So that evidence is produced to show that here the reason he knocked down because he wanted to eliminate him because of the litigation which I have filed in this Bombay High Court for his eviction from the premises, which judgment is awaited or judgment is given, matter pending in appeal. So that is a corroboration. You are corroborating the cause of death. A supporting evidence is called corroboration. समझे ना आप? Like statement given,
Yes,
statement given by you to the police officer under 161 is no evidence. But you must go in the box and give evidence, and your friend who was next to you, you will also support your evidence. Yes, he was there and I too was there. So the evidence of your friend is called corroborating your evidence under section 156. Means supporting your case is called corroboration. Supporting the medical evidence, the doctor's evidence is evidence that here the deceased person gave this evidence. She was knocked down by the motorist who was the neighbor, and she told me that relations are strained on account of a litigation. So the wife gives evidence and produces the case papers. Yes, there is a litigation pending. As a result of the litigation, he has got enmity in retaliation. खुन्नस में आके knock down कर दिया. ना रही बांस, ना रही बांसुरी. Isn't it? That is how he has got eliminated. So the modus operandi was to kill him. The motive, preparation, conduct. So his motive. That is the evidence of a third party who supports the evidence of a medical officer is called corroboration. Okay? और कुछ पूछना है?
Yes, sir. So I just wanted to ask you, why is it written as it is rarely to be found that the description of the incident is corroborated?
No, it is not.
I didn't understand.
It is not rarely, because if evidence of a witness A is not clean, the court is not accepting. Because under section 59 of the Evidence Act, evidence must be direct. If your evidence is not direct, if evidence is direct, it is not, court is not convincing, you may examine your neighbor to prove your case. अगर defamation में बोलेंगे, A has abused me openly in the presence of my friend. He has defamed me. So your statement, you will examine your friend. Yes, the accused person indulged in a campaign of vilification, abusing me. So the evidence of your friend supporting you is called corroboration. Understood?
Yes, sir. Thank you.
और कुछ पूछना है पूछ लीजिए. Your evidence will be under section 59. Your friend's evidence and corroboration will be under section 156. Okay, please note that. Your evidence will be under the provisions of the Evidence Act section 50, open it section 59. That is oral evidence must be 59 and 60. Oral evidence is direct. Agar wo evidence is not convincing to support your evidence, your friend is supporting you, that he is corroborating you under section 156. याद रखो. Section 60 supported by section 156 of the Evidence Act, where evidence is supported. Supporting evidence. Like 114A के अंदर of the Evidence Act, I read it to you, that the court may presume, what is the 114 खोल लीजिए. 114 के अंदर the evidence of the court should not rely upon the evidence of see that the accomplice, illustration B पढ़िए 114. Accomplice is unworthy of credit unless corroborated in material particular. So A and B are accused of killing B. A and B are accused of killing C. In a joint trial, A impledes himself and also impledes B. His evidence is unworthy if another bystander gives evidence, corroborate. Yes, I also seen A and B bumping off or killing C. So the evidence of A is corroborated by D. समझे ना आप? So the word corroboration यहाँ पे use किया देखो 114 clause B, illustration B. Anybody has any question now before we wind up for the day? The next lecture on Monday on Evidence Act will be some judgments I'll quote you. The nature of evidence के ऊपर and the CPC के अंदर entire provision relating to evidence in nutshell. I'll wind up also again in CrPC how the session judge records evidence, how the magistrate record in warrant cases on police report, and how the magistrate record evidence in cases otherwise than a police report, how the magistrate record evidence in summary cases, and how the magistrate record evidence in summary cases. Okay, 5 types of trial, criminal trial and civil cases, as well as the Evidence Act, and before tribunal के अंदर whether evidence is applicable, not applicable, before the arbitrator applicable, not applicable, I will give you the illustration and cite it. Okay, shall we wind up for the day unless anybody has any question?
Sir, good evening, sir. Sir, I have a question to ask.
Yes,
Sir, suppose a prosecution has filed a list of witnesses before the court, but maybe accused is having an apprehension that they might left some witnesses which would ultimately get be benefited to the accused. So, can he make an application to court that these witnesses should not be left out at the stage of trial from being testified in the court?
He can examine them as his witness. Who bar? There is no bar. It is the prosecution's privilege to examine whom to examine, not to examine. Accused cannot dictate. Prosecution must dictate A, B, C, D. If they are not examining, you have a right to examine them. Huh? The provision of the provision with regard to accused person can competent section 315. You can examine witnesses. There is no bar. You examine them as your witnesses. But you cannot say to prosecution, you examine. If the prosecution does not examine a witness, you can tell the court to draw adverse inference. It's good for you.
But sir, ultimately, if the accused is going to rely on the witnesses which prosecution was going to, isn't it that he is going to lead negative evidence because his right of cross-examination will be forfeited?
No, I will tell you, because if the prosecution is not examining, in a criminal trial, the prosecution must prove the case beyond reasonable doubt. So the public prosecutor must take care to prove all the witnesses. If he doesn't examine witnesses, you stand to gain as an accused person. Why should you bother? Because in a session trial, when you open, you are not permitted to examine witnesses if the court is satisfied that prosecution has not established the case. Open to section 225 खोलेंगे आप 225 से evidence to the evidence 231 के अंदर evidence for the prosecution. 232 में acquittal if the court is satisfied. If the prosecution evidence is weak, you are not even called upon to examine. Then under 232, you can enter your examination. You can examine your witnesses. You mean to say that you want to cross-examine them?
Yes, sir. Because he is having apprehension that that the prosecution will examine this this important witness at a later stage, maybe at the end of the trial.
Under 311 CrPC, everybody has a right to examine anybody. See, power to summon material witnesses, examine any person. There is a lot of scope. You may also tell the court, I want to examine XYZ. Prosecution can examine. Under 311 CrPC, the court may recall any witnesses. Everybody has a right to examine witnesses, re-examine witnesses. You have a right to, suppose if the prosecution not examining a material witnesses, that will be to your advantage according to me. You should not bother about it. Then if you think that he is a very important witness for you, you make application to the court. Convince how it is important for you. What point you want to prove from a person who is against you. Normally, you are not allowed to examine the prosecution witnesses. The earlier law of the Privy Council used to allow, but thereafter they started their practice. It is not proper to examine the witness of the other side.
Yes,
sir. The court will draw adverse inference. Under section 114 of the Evidence Act, बताऊंगा आपको, non-examination and non-protection of a material document, the court will draw adverse inference against them. Why do you worry? It is not your duty to prove the case. In a criminal case, the duty is upon the prosecution to prove the trial, to prove that they're beyond reasonable doubt. In a civil case, the case is decided on preponderance of possibilities. Court may draw inferences, but not a criminal case. Criminal case cannot be decided on preponderance of possibilities. Strict obligation upon the prosecution to prove beyond reasonable doubt, unless the accused has taken the plea of insanity, unless the plea he has taken one of the exception under section 80, 81, 84, 85, 86 of the Indian Penal Code, then you prove it. The burden will shift upon you. If you say that I have committed the murder sudden and grope on a sudden grave provocation as an act of self-defense, then you have to prove it. If you don't prove, that means you are admitting the guilt. You say that it's a self-defense, a grave provocation. Or you may take up the plea, I was a child, or I was suffering from insanity, I was in drunken condition. Those are exception. From 84 to 87 onward check कर लीजिए आप. Okay, is that clear?
Okay, got it, sir. So one more question, sir.
बोलिए.
At the time of trial, so is it how to one should how a trial lawyer should examine the prosecution witnesses, because prosecution will play smartly. They will try to disclose your defense before the, I mean to say कि आप कब उनसे किस विटनेस को पहले कॉल करें कि because there will be some important witness related to case.
135 of the Evidence Act, the court will decide it, whom to be examined. And under the provisions of Order 16 CPC, the list of witnesses to be given. Under Order 18 Rule 3A, there is a provision you may examine with the permission of the court any witnesses you want. The line of action is that is your discretion. Prosecution may examine A witness, B witness, serially, non-serially, उनकी मर्जी है. And you also as a defense lawyer, you may examine your witnesses the way you like it, subject to the court permitting you. That is the section 135 of the Evidence Act. पढ़िए ना आप. Okay, मैं बताया था आपको. The court will decide it, or you may also decide it. You convince the court, I like to examine first suppose you are taken up the plea of defense that you are suffering from insanity. You will examine your doctor first, isn't it? Before you going in the box, insanitically you require medical evidence, isn't it? You will examine your psychiatric. You yourself cannot go in the box, I was suffering from some A disease, B disease. You examine your medical officer, he will prove the record.
Okay, sir. Got it, sir. Thank you, sir.
Yes, my pleasure. Anybody else? Okay, then we'll wind it up and Monday we'll be Monday 7 o'clock. Okay. All of you, those who want to watch Justice Felicitation of Justice Oak, I will forward the link to you.